Mkhwebane is waging yet another legal battle aiming to return to office. She scored a victory last month after the High Court declared her suspension unlawful. However, that ruling is being challenged by the DA and President Cyril Ramaphosa. At the same time, the High Court's ruling must be confirmed by the Constitutional Court before it is effective. Now Mkhwebane is at odds with the interpretation of the High Court judgment that its decision must be confirmed by the Court. She argues in court papers that there was no party that raised the issue of confirmation by the Court, nor did the full bench raise the issue during her urgent application. This in response to the High Court's ruling that there was no need for it to state categorically in its September judgment that the ruling would have to be confirmed by the Court. Mkhwebane argues that the court erred in repeatedly stating that the judgment has no force or effect until the Court confirmation, because if the judgment had no effect, then it should not be able to be appealable by the DA and the President. Mkhwebane also takes issue with the High Court, arguing that it was erroneous to expect parties to apply common sense by assuming the judgment is subject to confirmation when the registrar did not interpret the judgment needing confirmation by the Court. She goes on to say the registrar was not directed to refer the High Court judgment to the Court until the prescribed expiry of the 15 days had elapsed, because the High Court had made no such indication to the registrar. Mkhwebane concludes to say this matter cries out for an interim protection of her right to work. Meanwhile, the Court is expected to hear the DA and the President's appeal, as well as consider the confirmation of the High Court judgment on 24 November. Ulelani Philip, SABC News, Cape Town.